Good afternoon and welcome everybody to this Lunch and Learn session on legal terms and conditions in public procurement. For those that have joined me before, you'll know who I am. For those who are joining for the first time or who are watching this on replay, my name is Gillian Askew and I'm your host for this session. Just while people are joining us, I'll do a quick intro. I'll run through the agenda and some housekeeping. I'm one of three co-founders of Go for Growth, an organisation that was set up and is dedicated to supporting smaller organisations, small to medium enterprises, voluntary sector organisations. That includes sole traders and micro organisations to navigate the public procurement landscape. And we're all about helping organisations to deliver sustained growth over the longer term. The session is being recorded today, and a copy of the recording and the slide deck that I'm using today will be sent out to all registered attendees. We normally try to do that within 48 hours, but it actually will be next week when the recording and the slide deck comes out, just due to annual leave and Go for Growth. As we're on Zoom today, as always, you can use the chat functionality. If you would like to say hi and introduce yourself, please feel free. And the Q&A functionality should be enabled also today. So please feel free to use both. I have carved out some time for questions at the end, but feel free to pop them either in the chat or the Q&A. I'll keep an eye on both as we go. So what will we cover today? I'm going to focus on a few terms and conditions, pulling out those main areas of focus. So things like warranties, liabilities, cost increases, termination, intellectual property rights, that kind of thing. Do want to just remind everybody that there should be no confusion that this session does not constitute legal advice. I am not a procurement lawyer, and the information hasn't come from a procurement lawyer. So this is guidance from a practitioner's perspective only, and shouldn't be a substitute for legal advice if that's what you need. So please do, if you need legal advice, reach out to a lawyer. If you're a member of Federation of Small Businesses or your local chambers or other membership organisations, it may well be that you have free legal advice at your disposal. Also, just to note that I am covering today standard goods and services contracts. So what I won't be looking at is software as a service, so SaaS contracts, or any of the more detailed construction contracts such as NEC3. So we are just looking at standard goods and services today, and these are clauses that you will likely see in all of those types of contracts. So it's a short session today, so we'll skip on. So I'm going to cover these first. So it sounds obvious around pricing clauses, but contracting authorities will always be trying to work out what the cost of this goods or services are going to cost them for the duration of the contract. And pricing clauses can give you a really clear indication of how long the pricing is applicable for and what mechanisms, if there are any, are available to levy increases. You should be aware when you're looking at the invitations to tender that all of this information will be transparent to you, so you will know upfront what the pricing clauses look like. Some authorities will be looking for costs that last the whole life of an agreement, even if that's 4 years. Some will ask for annualised pricing or allow increases in line with inflation. If you've got any questions on how pricing is structured or how it's reflected in the contract, if you're unclear on any of that stuff, it would be our view that that would be a good thing to ask as early as possible through the clarification process in the invitation to tender. Usually where there are price increases that are permissible, they are often evidentiary processes, and they're often linked to things like indexation. So that could be the consumer price index or the retail price index. You might also be allowed to submit some pass-through costs. So that is allowing suppliers to legitimately cover cost increases and specifically or usually especially those unforeseen price increases that you couldn't have known about at the point where the pricing was submitted through the contract. There may be caps or thresholds to that pricing, so some contracts will limit the percentage by which prices can increase annually. But again, they're usually linked to some sort of indexation, either CPI or RPI, that kind of thing. In terms of termination, there are different methods of termination that you'll see in a contract. The most usual one that I guess we would see is termination for cause. So that termination for cause, termination in general specifies when and how a contract can be ended by either party. Termination for cause usually has mechanisms for both buyer and seller. And it's usually for some sort of breach of contract that has been unrectified or is of such a magnitude that it requires immediate termination. The grounds for termination, as in, and actually, I will say this on all of it, all of the grounds, the detail behind all of these contract terms should be really clear, and all of the information will be included either in the invitation to tender, or it will be included in the terms and conditions, which you are not required to sign before at the point of bid, but you are always given a copy of those terms and conditions so that you can ask any questions, because you will be required to sign them if you are successful. So usually there is a termination for cause, which is generally speaking around some sort of breach of contract on either side. So the grounds for that termination for cause must be explained in the procurement documents. There is also something called termination for convenience, which allows, usually with a notice period, and what you would probably see is it will allow the customer to withdraw for any reason. What I see more often than I would like to see is that is a one-way clause. So it doesn't necessarily mean the provider, unless it's explicit, it doesn't always mean that the provider also has that mutuality of that clause. If you don't have the ability to terminate for convenience in that mutual sense, then you can ask a question about that in the clarification process as well. Often you are reliant on breach of contract by the customer as a provider. It's not unlawful for that to happen, by the way, is my understanding, that it's perfectly legal for that clause to only be a one-way clause. However, my personal view is that if you are putting a termination for convenience clause in as a client, you should make that mutual, and the termination notice period should be proportionate to the contract and value, duration, complexity, and value, etc. So have a look at the notice period and see how long that is. What you're trying to understand is what your financial burden would be if that termination for convenience was invoked by your client. So if it's a 3 months clause, but you have redundancies to make, then potentially you wouldn't be able to do that within that 3-month period. So you might ask that it is a 4-month or a 5-month or a 6-month period, and you would ask for that to be mutual also. So have a think about that termination for convenience. It might not be in there, but if you think it's a clause that you would want in there, then again, the clarification process is where you would go. If we think about warranties and representations, so what are they? Warranties are legally binding promises about the product or the service quality, delivery, and compliance. And a representation is a pre-contractual statement made by suppliers that could, in fact, influence the buyer's decision. And they're important because if warranties are breached, the buyer may claim damages, and misrepresentations can lead to contract rescission or financial penalties. So it's important that we understand what we're being asked for in terms of warranties and representations. And so in addition to the regular goods warranties that are usually around goods being fit for purpose under the Sale of Goods Act, for example, so they're fit for use, they are as they're supposed to be, you might be asked to provide warranties and representations around things like that you have the capacity and the authority to perform the contract, and that you have all the necessary licenses, accreditations, authorizations, and consents in place, including but not limited to any that have been asked for during the bid process. And that's all about making sure that you have everything that you need in which to operate the contract should you be successful. These are often on a self-cleaning basis. So you may have to self-certify that you either have or will have these things in place by contract start date, all the things that are required to operate the contract compliantly to the organisation's requirements. So common examples of warranties and representations are supplier warrants that a product will meet a specified performance standard, or a service provider might represent that they have the necessary qualifications to perform the work. In terms of liabilities and therefore indemnities, these will differ, as most things will contract to contract, to be fair. But liabilities will lay out what each party is responsible for. For example, it will be defining each party's legal responsibility for losses, damages, and any indemnification that is required. So, for example, it might say that no party is liable to the other for any indirect losses, loss of profits, turnover, or damage to goodwill. And so it's probably good to always check what you are required to indemnify your customer against and whether you would need insurance to cover that. So, for example, death and personal or personal injury due to negligence cannot be excluded by either party on any contract. And if TUPE is applicable, and that's the Transfer of Undertakings and Protection of Employment legislation, where it looks at people who would transfer from contract to contract. If TUPE is applicable, that can be a very complex piece of law, especially where pension liability is concerned. So it's an area definitely where we would be saying, have a think about getting legal advice. The liabilities and the indemnities are one of those where you would need to understand your risk. So what are you signing up to? And they can be complicated. TUPE is a piece of law that is fairly complex. So it is always best to understand what you are being asked to do, and then to judge yourself if you think it is proportionate and relevant to the contract value and the contract duration. If we think about intellectual property, for example, this will determine who owns the rights to intellectual property, either created during or used in the contract. And you'll see things like foreground and background IP. So when you go into a contract, you might be already taking assets that you own the intellectual property on, and you want to make sure that the contract preserves that ownership throughout the duration of the contract, so that you are not assigning ownership of that intellectual property or a license to use that intellectual property unless you're comfortable doing so. What we would advise is that be clear on what you already own, be clear on what your potential or new customer already owns, and be clear on what intellectual property will be created throughout that contract and who will own that. And be very clear on what happens to the intellectual property rights at the end of the contract. Do those things feel okay to you? Are you happy with them? And again, it's one of those, if you're not, I would seek legal advice to help you navigate intellectual property. You'll see things in IPR called, you would be assigning I can never say this word, irrevocable license. You might be granting effectively your customer a license to use the IP. So you would have to think about that confidentiality, third-party rights, and when that stops. Does that stop when the contract stops? Are you happy with that? So be clear on what you own, be clear on what your client owns, be clear on what's created throughout the duration of the contract and who owns that created intellectual property and what happens to all of that at the end of the contract. In terms of payment terms, most contracts will have existing standard payment terms. Post-COVID, we saw for small businesses actually some payment terms reducing. So they might be 15 days, but more often, and I believe in the Procurement Act, there is now a payment notice and a supply chain payment mechanism so that 30 days becomes the holy grail. Don't quite quote me on how the Act is catering for that, but there is certainly more focus on on-time payment throughout the supply chain through the Procurement Act. There is also something called the Government Prompt Payment Code. And I guess one of my messages is don't feel you have to just accept the payment terms if they are unusually long. For example, normal payment terms would be 30 days from date of invoice. As I've said, lots of public sector organisations have shorter payment terms. The smaller organisations, some I've seen have been as short as 5 days. You can inquire through the clarification questions as to whether any of those facilities exist for shorter payment periods, if it's not mentioned in the documents linked to being a smaller business. Payment of any invoice will almost always be conditional on having the correct information contained in the invoice and submitted in the correct format to the right place. That might be electronic. And you will almost certainly always need a purchase order. Things like energy might be different, but almost always a purchase order will be required for accurate invoicing. So make sure that you understand what those invoicing processes are and that you have all of the correct information when you're invoicing. There might be, and we're not talking about construction contracts particularly, obviously today, but in some such contracts, you might have things like milestone payments. So payments are linked to particular project phases or project deliverables. And you might also have retention payments in some contracts where a percentage of the payment may be withheld until project completion. But again, in the documentation that it comes out with the tender that you're looking at, all of those payment terms, including the invoicing processes, should be transparent for you to see. And in terms of confidentiality, it's an opportunity for us to check what we are and what we're not allowed to say in connection with the contract. So the procurement process in and of itself is confidential, but you'll be required to keep any confidential information that you receive during the course of the contract, and usually for a period thereafter. But have a look at what that confidentiality term looks like. There will be conditions around that. So if the information becomes a matter of public record, for example, then confidentiality changes over time. There will also be freedom of information declarations. So you also, as a bidder, have the opportunity to request that some information that you are submitting during the bid is not admissible under freedom of information requests. So normal things that you might think about would be your pricing. You would think about any commercially sensitive information. Recently, an organisation I was chatting to wanted to include their business continuity processes under that FOI table that you get in any bid. So you do also have the ability to request that some of your information that you submit as part of your bid is not subject to FOI. And that will be reviewed by the client with whom you're bidding. And if anything isn't accepted under that FOI, they will let you know, and you can discuss that. There will be conditions where you disclose if it's required by law, and again, if it becomes a matter of public record, or if you require the information in order to be able to operate and fulfill the contract. So that would normally sit outside of confidentiality. But under general data protection regulations, you will almost certainly be asked to declare that you will be compliant with GDPR. And so it is worth also understanding what personal data actually means and look like, and are you collecting it, and what are you doing with it once you have it, and are you managing it? Are you making sure that people can exercise their right to be forgotten? So some key areas for you to think about and focus on. So insurance will be specified in terms of what you need to have as a minimum, and you should be asked to have those in place for contract start date. You should not be asked to ensure that you have them in place at time of bid. Usually the wording will be something like you either have or will have the following, and that's to avoid actually the provider paying for additional insurance until they're awarded work. Insurances will need to be in place throughout the life of the contract, and some may specify for a period thereafter. I have seen 6-year periods thereafter. If there is an insurance that you don't believe is necessary or proportionate, you can ask that question via the clarification process. It might be that you're asked for cyber insurance and you don't feel that that is particularly relevant to this contract, then I would certainly ask that in a clarification question. Also, cyber insurance can be an expensive insurance to get, so it is worth doing your due diligence on that. Generally speaking, you'll be asked for public liability, employer's liability, professional indemnity or product liability as well. And those are the usual ones. If you are in construction, you'll be asked for contractors all risk, for example, construction all risk type of insurance. There'll be other insurances as well that should be proportionate and relevant to the particular procurement that you're looking at. In terms of data sharing and data processing, contracts will differ, but you might be asked to provide a data processing or data protection privacy policy information. You might be asked to sign a data sharing agreement. Data can be a complex area, and again, one where we would advise seeking legal counsel about what's required. If all else fails, or as a bare minimum, make sure that you have a privacy policy, it's up to date and it is visible and accessible. So usually on your website or somewhere like that. In terms of data sharing agreements, they ensure compliance with GDPR and the Data Protection Act. You will be looking for your roles and responsibilities, the security measures that you would be subjected to, and data retention and data deletion. So that records management type of environment as well. In terms of media and publicity, always check if you are able to tag your customer in social media or use their name in articles, advertising campaigns, etc. Usually that won't be allowed without express written permission unless the core contract is for those types of services. So do just have a look at media and publicity. There might be restrictions on that, on your use of their logo, their name, etc. So definitely have a look at that. In terms of variation, this speaks to how changes in the contract are made, and they'll be detailed in the contract. So any changes to specification might trigger pricing changes. They can be to your benefit, but they can also be to your detriment. So, and a material change is what we're really interested in. A material change is something that is a significant change to the contract and changes the materiality of the contract. If you get a material change at the request of the customer, it should be reviewed carefully before agreeing it, as it might change the nature of the contract itself and potentially should be dealt with in a different way. Changes of that nature may also attract cost changes, so you might need to reprice based on variations. You can also request a contract variation that will usually be subject to a materiality assessment by the client. Does it change the core nature of the contract? And you would follow the variation process stipulated by the customer, which should be clear. That variation process should be clear in the procurement documents. If the bid documents don't include information on contract variation, you can ask for it during the competition window through clarifications again. In terms of contract extensions, often frameworks and contracts are let with a core term and then extensions. So a 4-year contract might be a 2+1+1. So the core term is 2 years, and then there are a 1 year and a further 1 year extension. Those extensions are not guaranteed. So it's worth understanding at the outset how those extensions will be invoked at the point of bid. Those internal processes can often change, budgets can often change. So you want to be clear on whether you're bidding for a 4-year contract or a 2-year contract. And it can really change how we submit our bid and our pricing. You will only be guaranteed the initial term. The extensions are not guaranteed. So even where there are indications of work, they are unlikely to be guaranteed. So it's worth understanding if it doesn't feel clear how those extensions will be invoked. And then finally, dispute resolution and law and jurisdiction. They detail how any issues are dealt with and under what legislation. So usually a contract in England and Wales will be governed by the English law courts. It is likely, however, that if you have a contract in Scotland, that might be governed by Scottish law. And Scottish contract law does differ from the law of England and Wales. I'm not familiar with the contract law in Northern Ireland, but it may well be that they differ also. But what they're talking about is if we end up in dispute, where will arbitration be held, and how will what law will govern the contract and therefore any dispute resolution. If you do end up in dispute, usually there is a process that this goes through. So you would try and resolve the issues through a period of good faith attempts. Then there would be a period of arbitration that comes after that. So the timescales for escalation should be quoted also as part of that contract. And so the final thing to say, and then I'll open up for some questions, is we know this all feels really complicated. It's not necessarily easy. I've dealt with contracts for 30 years and I am not a lawyer and don't profess to be one. And so things move around. We have got new regulations in England and Wales. So, you know, we have got the Procurement Act 2023, we've got the provider selection regime, we've got the public sector processes in Scotland and Northern Ireland. So these things do move around. So if you have any questions or if you feel like you need any help, if we don't know the answer, we will certainly try and signpost you to someone that does. If you would like to stay in touch with us, as always, you can do so through our newsletter. It comes out once a month. We don't spam you. You can opt out at any time. Please feel free to sign up to that should you want to. And that is it from me. So we've got a few minutes left. I'll double check. I'll stop sharing my screen and I'll see if we've got any questions. Let me see if we've got anything in the Q&A. So nothing in the Q&A just yet or the chat. What I hope is, although that was a super whistle stop tour, I hope that it has been in some way useful and helpful to have an overview of what those common clauses are, what they mean, and the kinds of things that you can do. I think the underlying message is in any public sector procurement, transparency is key. So you should have all of the information that you need in those documents, but if you don't, then the clarification process is there for you to double check. Remember that clarification processes are time sensitive, so they do usually have a closing date on them. So have a think about what questions you've got and when you want to ask them. I won't keep us all here because it is a lunch and learn. Thank you ever so much for joining us today. I hope that was useful. Have a good rest of your Monday, and we are next Monday at 12:30 looking at the feedback process. If anybody would like to join us, please feel free to do so. See you then.